Hey guys, buckle up. Today's video begins with pure courtroom chaos. We start in Kansas with two sovereign citizens, each convinced they've cracked hidden legal codes that every lawyer, judge, and law school overlooked. Right from the start, the confidence is high, the logic paper thin, and the reality check is brutal. One defendant already faces fines and appeals, and his attempts to bypass legal procedure are about to collide with real courtroom authority. This opening sets the tone. Fantasy meets law, and the consequences are imminent.
Appearing in person and pro se. The defendant was found guilty February 14th, 2025. Ordered to pay scheduled fine in 108 within 15 days. And what have you done about that, sir?
I submitted the notice to appeal.
Okay. And have you done anything to perfect that appeal with the Kansas Court of Appeals?
I'm waiting. I literally just spoke to the court record, and they send it in, and the next thing is we're just waiting for the plea.
All right. First of all, I'm not making if Mr. McClendon has not withdrawn, I'm having him do so now because we do not, to my knowledge, pay for appeals of illegal tags. You'll need to be responsible for that yourself. And it's not enough just to file the notice that you intend to do it. You need to actually do it. So are you going to be representing yourself or hiring an attorney on that, Mr. Estrada?
I would like to get an attorney.
Well, you're going to have to hire one because throughout the trial, you kept insisting that if I'm remembering correctly, you didn't want an attorney. Isn't this one where I made Mr. McClendon stay on as kind of a backup counsel?
That's correct, Your Honor. He was essentially became standby counsel, and the court granted Mr. Estrada basically special consideration on this matter, as this is not even a offense that's eligible for court appointment, as it does not carry a sentence that exceeds 6 months.
Oh, yeah, yeah.
And I thought the court, I was going to double check the journal entry. I was thinking Mr. McClendon, maybe even on the last journal entry, had been allowed to withdraw, but there was a delay in me giving those journal entries to the county attorney's office, because I had a few to complete after that day. So they had not all been emailed in. So I think that they might still be in the process of being e-filed, because then the following week, as I recall correct, I didn't travel to Greenwood County because of all the snow.
Okay.
I did my meeting with the commission via Zoom. So, but today the court's ordering that Mr. McClendon is withdrawn. Mr.
Yes,
Abel
because
directed or advised he should perfect his appeal.
And I'm going to set his pay or appear over 30 days to see if, and remember, you were to pay a $158 cash bond. Did you do that when you filed your notice of appeal?
I'm sorry, can you repeat that again?
I had ordered that if you appealed, you had to pay a $158 cash bond. Did you pay that appeal bond?
Watch closely as the Kansas defendant struggles with the appeal process. He filed notices but hasn't perfected his appeal, missed cash bond requirements, and now faces the reality of responsibility. The judge is firm yet fair, emphasizing procedure and deadlines. Any attempt to rely on pseudo-legal maneuvers is immediately crushed by established rules. This is the moment fantasy collides with reality, showing that in court, intent or belief matters far less than following the statutory obligations laid out by the system.
I haven't seen anything about a waiver. Mr. Dean, have you seen anything about a waiver on his appeal bond?
No.
Well, I would deny any appeal bond. Mr. Abel, the facts in this case were very straightforward. You'd made up or bought a made-up alleged tag that wasn't even close to being a legal tag. We spent a lot of money trying it, and I say a lot of money because I made the defense attorney stand by, even though you didn't want an attorney. Now you say you want an attorney to appeal it. Well, I'm sure not going to appoint one to appeal it. And if you cannot even afford your $158 appeal bond, I'm wondering how you're going to afford your attorney if you can even find one to take this kind of case on appeal. I would venture to suspect that it's never been done before, but if you think you can get it done, you're welcome to. But I am proceeding that until that appeal is perfected, you still owe $158 fines and costs, and you need that to pay that appeal bond. So I'm going to review this in 30 days, and you better have it all figured out, or you better have it all paid.
I actually started the process, and I send up the appeal notice, and I actually send I requested what's it called? The report. No, the journal entry from Mr. Dean office, but I haven't got it because the journal entry reflects $50, but I never got it. I never seen the charges or the journal entry. I'm trying to get all the information in.
That's all great, Mr. Estrada. The journal entry is being filed. Your Honor, I don't know that at least the state's not particularly interested in his steps to appeal. That's for him to figure out on his own. I do have one item to correct on the record, Your Honor. I think probably it's proper to note that Mr. Estrada was wanting counsel. However, both court-appointed counsels, Mr. Paul and Mr. McClendon, both believe that Mr. Estrada was also wanting them to violate their oath as an attorney and make arguments
that is incorrect.
Don't interrupt, please.
And make arguments in violation of both the U.S. and Kansas Constitution was the specific statement both attorneys made to this court.
Yes. So,
that was all. I just wanted to correct it because he was asking for an attorney, even though, quite honestly, the case doesn't qualify for court appointment.
Oh, thank you for correcting the record.
The court still did grant him that an attorney, but the attorney's Mr. McClendon became standby because he believed that the arguments were not supported.
As proceedings continue, the judge clarifies representation and the limits of court-appointed counsel. Even experienced attorneys are unwilling to violate their oath to support the defendant's arguments. That alone sends a clear signal. When professionals distance themselves from your legal strategy, it's not the court that's unreasonable. This is a classic red flag for anyone tempted by sovereign citizen claims. Misunderstanding the law leads to isolation in court, where every choice has measurable consequences.
And it looks like from my docket notes, he was just ordered to pay 108 court costs. It says scheduled fine, but isn't this a misdemeanor?
I just asked for the basic fine. What I refer to as basic fine, it's not really a scheduled fine, but it was $50 because he did actually have it. He just refused to
put on his car.
Display it.
That's right. He refused to put it on his car, put on that cardboard.
Despite all the rigmaroles, I treated it just as any other case.
Okay. All right, Mr. Estrada, we're going to make you come back for another pay or appear in 30 days. Missy, when is that?
March 28th at 11 o'clock.
All right, March 28th, 11 o'clock. We're going to review this and see if you've paid your case and moved on, or if you're going to keep fighting it and never mind. All right, but I understand, Mr. Estrada. What is it you're appealing? The fine and court costs, or are you appealing the verdict?
I'm appealing the verdict.
Okay. And you want to maintain your argument that cardboard tag was legal. The tag that you made was legal.
Yes.
Okay. All right. I just wanted to make sure I knew what we were doing here. All right. I'll see you back here March 28th at 11, unless you paid your $158 balance. Thank you, sir.
Yeah. I just wanted to know, where do I get the report, the journal entry from Mr. Dean?
It'll be with the court. Look at the court.
Clerk of the district court is the keeper of journal entries.
You mean the court record?
The court records are all through the clerk of the district court.
Okay, thank you.
They're the public record holder. Yes, sir. And that's about all I can advise you. I'm not going to help you practice.
The case moves forward with fines, appeal bonds, and future court dates. The defendant's reluctance to comply with basic procedures only compounds his difficulties. Each defiance, delay, and misstep strengthens the state's position. Courts operate on rules, deadlines, and statutory authority, not beliefs or personal theories. What might seem like minor paperwork or technicalities quickly becomes critical, underscoring the harsh reality of navigating the legal system without proper guidance.
Kansas versus Jesse Travis McLaughlin. It's case number 2024 CR 397. Mr. McLaughlin appears from a Hutchinson Correctional Facility Zoom location. Brett Sweeney appears for the state of Kansas. Mr. McLaughlin, I have before me a charge of battery against a law enforcement officer, a level 5 person felony. Since a felony is involved, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McLaughlin, that you, being in prison, don't have the financial resources to hire your own lawyer.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in
man
the
must
abundance of
speak for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point of
represent.
order. What gives you jurisdiction to appoint a lawyer over me?
I have statutory.
Next, we transition to Michigan, introducing a new sovereign citizen claiming royal status. Despite asserting privileges under international treaties and maritime law, the courtroom reality remains unchanged. Judges here don't negotiate fantasy claims. They enforce the law. From bond requirements to restrictions and mandatory procedures, the system imposes accountability. Representing oneself without understanding the law is an invitation for chaos. And this segment demonstrates precisely how sovereign arguments unravel when confronted with concrete legal standards.
And who is the individual? And sir, what is your name at the jail?
I'm Roman Campbell. I mean, I can place my status on the record if you like.
Yeah, hold on one sec. Yeah, I'll get to you. 1 second. I need to look over some things. Are you representing yourself?
No, sir, I'm not representing myself. I'm presenting myself.
Okay. I mean, do you have is a court-appointed attorney going to be speaking with you, or are you going to have a retained attorney?
No, sir.
Okay, calling case Tom King 25 William Boy 00474 in the matter of Roman Curtis Campbell. Mr. Campbell, would you please state your name for the record?
Yeah, I like to state
Just tell
my
me your
name.
name. Yeah, go ahead. Yeah, all I have to do is say it.
I'm Roman Curtis Campbell, a natural person full life.
Okay, let me ask you this question, Mr. Campbell. Let's try not to talk together. I mean, I'm going to allow you plenty of time to talk, but I have to. But are you representing yourself here today? You don't need an attorney, or you want an attorney?
No, sir, I'm not representing myself. I'm presenting myself. I don't need another man to present.
Are you presenting yourself? So you don't want an attorney, you're presenting yourself here today. Is that correct?
Yes, sir.
Okay. All right. Thank you, sir, for that.
You're welcome.
You're charged with domestic violence, as I've indicated. MCL 750.81, it carries a maximum penalty of 93 days in jail, possible fines of $500 and/or both, not including any court costs. I am going to enter a plea on your behalf of not guilty on this offense. You will be given an additional, and you're also charged with refusal for collecting fingerprints and data, which the court is ordering that you do that. As I've indicated, I'm in a plea of not guilty on your behalf for this matter. I'll indicate that you're self-representing at this time as well. I do have some other conditions for you before I set bond. You're not to have any direct or indirect contact with Marissa, M-A-U-R-I-S-S-A Smith. You're not to return to the premises known as Celeste Road.
That's my home.
I'm gonna keep going, and then I'm gonna take all your questions at the end. So, no problem. Just hold on to that question. That's all. You're gonna have plenty of time to talk at the end. So, do not return to the premises known as Road, West Bloomfield. You will not assault, beat, verbally harass, intimidate, or threaten any potential witnesses. Person may appear for all court proceedings. Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. You need to provide the court with a valid address within 24 hours of your release. Do not leave the state of Michigan without permission of the court. You will not possess any firearms or other dangerous weapons. You shall refrain from using alcohol, any form of THC, illegal drugs, or using any medication. You must contact pretrial services within 24 hours of your release. That's at the 48th District Court in Bloomfield Hills. Pick up no new criminal offenses. And I understand you're self-representing yourself here today. The court will set a bond in the amount of $1,500 cash surety, no 10%. Sir, do you understand your bond, what I read off to you, your bond conditions?
Yeah, I understand all of that, but all of that.
Okay, now I'm gonna take your questions right now. Thank you very much. So what questions do you have for the court?
Can I place my status on the record, sir?
Absolutely, sir.
Okay, I'm Roman Curtis Kempiel. I'm a natural person in full life, in propria persona, sui juris serheritis. My nationality and citizenship being Moorish American national, unconditional heir, apparent vessel for the.
Watch as the Michigan defendant mixes sovereign rhetoric with genuine procedural facts. Refusing counsel, claiming personal status, and asserting international claims, he creates a tangled narrative. The judge patiently explains legal authority, rights, and obligations, including bond requirements and reporting duties. Despite elaborate claims of immunity or exception, statutory law prevails. This illustrates a fundamental lesson. The law is applied consistently, regardless of perceived status or personal belief. Courtroom outcomes hinge on compliance, not creative arguments or self-perceived immunity.
Gate, Turtle Island, I come under protection by way of Treaty of Peace and Friendship, 1836, between United States Service Corporation and the Moroccan Empire. I also would like everybody else that's involved with this matter to place their status on the record, and so that it can be noted. And also, I'm not representing myself. I'm presenting myself. Not only that, I'm not standing a surety to Roman Curtis Kempiel in all capital letters, ins legis, corporate entity. So that be noted for the record, please, sir. I also reside in domicile at. That's my address. That's my home. The defendant, witness, or whoever that is, Marissa, she doesn't live there, and so that's where I was kidnapped from. That's my home, sir.
Okay, and I will allow you to go back there one time and one time only with a police escort to obtain some minor personal property. That's with a police escort only. Otherwise, you cannot go back.
Finally, we observe a child support hearing illustrating another common misinterpretation. The defendant treats statutory obligations as contractual options, hoping to avoid payments. The judge corrects these misconceptions, clarifying that child support is a legal duty enforced by statute, not negotiation. Attempts to impose maritime or sovereign law are rejected outright. Even with overpayments or misapplied payments, the process continues under state authority. This segment underscores the principle that statutory obligations are non-negotiable, and ignoring them triggers formal enforcement actions.
That date will be provided to you prior to you bonding out. If not, you're going to have to contact the 48th District Court in Bloomfield Hills. Other than that, best of luck to you, sir. Officer, we're all set here. Thank you very much for your time.
If I could, Your Honor, we would like the refusal of the booking process that he not be released until that is completed.
Absolutely, he must submit, as it relates to the booking, he must submit to the booking processing in this information, including fingerprints, which is the biometric data. He must provide that information prior to release as well. You're all set, officer. Thank you.
So I'd like, one more thing, sir, I'd like to invoke my treaty right to consular jurisdiction. I've been asking someone that's competent in the notification and access manual, and I haven't been given that right. My rights have been violated as far as all of that's concerned also. So.
Okay, make sure you mention that to the judge when you see the judge. So thank you very much, sir, for that. And officer, we're all set.
Thank you, Your Honor.
Okay, must submit the
The day ends with clear consequences: appeals, fines, child support reviews, and strict enforcement of court orders. Across Kansas and Michigan, judges are no longer tolerating pseudo-legal arguments or sovereign citizen claims. Authority is reinforced, timelines are set, and statutory obligations take precedence over belief or personal theory. The takeaway is unmistakable. Courts operate on law, not imagination, and ignoring that reality carries significant consequences. For anyone watching, these cases offer a powerful demonstration of accountability, compliance, and the limits of courtroom fantasy.